ancient Rome laws that only existed because one criminal was too smart. The story of Roman law is often told as a grand, logical progression. The 12 tables, the edicts of the praetors, the opinions of the jurists, culminating in the monumental codes of Justinian. It is a narrative of reason, order, and the steady march of civilization. But woven into this majestic tapestry are threads of pure chaos, laws born not from philosophical principle, but from sheer, exasperated necessity. This is the story of one such thread, a legal tapestry spun from the brilliance and audacity of a single man, Gaius Aquilius Florus, the man who broke Rome's logic. To understand the impact of Florus, one must first understand the world he exploited. The Roman legal system of the late Republic circa 100 to 50 BCE was a fascinating, patchwork creature. Its foundation was the Aya Civile, the civil law applicable only to Roman citizens. It was formalistic, rigid, and obsessed with specific words and gestures. A contract wasn't about intent, it was about pronouncing the correct formula. Property wasn't about possession, it was about following the precise rites of mancipatio. This rigidity created a predictable, if inflexible, world. But Rome was growing, and commerce was becoming complex. To address this, the office of the praetor became the engine of legal innovation. Each year, the praetor urbanus would issue an edict, a list of legal remedies he would grant. This was the ius honorarium, the law of the magistrates. It didn't abolish the old Aya Civile, it effectively bypassed it. If the strict civil law produced an unjust result, the praetor could grant a new action or exception to achieve fairness. The system relied on a delicate balance. The old law provided stability, the praetor's edict provided equity. It was a system confident in its own ability to plug any hole, correct any injustice. It had not yet met Gaius Aquilius Florus. Florus was not a brigand or a cutthroat. He was a knight, of considerable wealth and education. He owned shipping interests, lent money, and dabbled in the lucrative business of state tax collection publicani. He was, in short, a man who understood systems, their strengths, and more importantly, their pressure points. His criminality was not of violence, but of abusive litigation and fraudulent contract. He didn't break the law, he made it dance until its legs snapped. The infinite loan. The cornerstone of Roman contract law for loans was the mutuum, a loan for consumption of money, grain, or wine. It was a bona fide contract good faith, but its stipulations were clear. Upon default, the creditor could sue via an actio certi crediti pecuni. The law also recognized suretyship ad promissio, where a third party guaranteed the debt. Florus saw a loophole not in the law itself, but in its interaction with procedural limits. He would approach a young, profligate patrician, Marcus, and offer a generous loan at a legally acceptable rate. He would, however, insist on a chain of 10 shorties, all of whom were, unknown to each other, men of straw, freedmen or small farmers whose assets were secretly controlled by Florus through intermediary agreements. The loan contract contained a fiendish clause, written in flawless legal Latin: in the event of default, the creditor may, at his sole discretion and in any order he chooses, pursue the principal debtor or any one shorty, or all shorties in sequence, for the full and entire sum, without prejudice to his right to subsequently pursue the others for any remaining balance. Marcus would inevitably default. Florus would then sue not Marcus, but shorty number 1, a poor freedman. The court would find for Florus. The freedman's meager assets were seized. Florus would then immediately sue shorty number 2 for the full original debt again, arguing the first judgment had not extinguished the obligation, as the clause allowed pursuit of any one shorty for the full and entire sum. The praetor, bound by the written contract's terms, was forced to grant the action. He would win again. By the time he reached shorty number 5, the scandal was enormous. He had extracted over 5 times the original loan amount from men who were legally liable but morally and economically victims. The original debtor, Marcus, was untouched. When the Senate howled, Florus produced his contract. He had broken no law. The formulas were correct. The shorties had consented. The praetor's existing edict on fraud dolus malus was too vague. It required proof of deceptive intent at the time of contracting, and Florus's intent was hidden in plain sight within the contractual language. The exceptio doli specialis, the special exception of fraud. The praetor of that year, Servius Sulpicius Rufus, a legendary jurist himself, was apoplectic. He could not change the ius civile on contracts. So, he crafted a new weapon in his edict, where a plaintiff brings an action arising from a contract, and the defendant pleads that the plaintiff is doing so in a manner which, while technically permitted by the letter of the agreement, constitutes an abuse of his rights for the sole purpose of unjust enrichment beyond the substantive obligation, I will grant an exception. This was the exceptio doli specialis. It was no longer enough to prove fraud in the inducement. A defendant could now argue fraud in the execution. It was a direct judicial rebuke to Florus's brand of predatory formalism. For the first time, the spirit of a transaction could blunt the letter of it, even in its performance. The ghost ship. Undaunted, Florus turned to maritime law. Rome had a sophisticated set of rules for sea loans finis nauticum, where the lender bore the risk of the voyage. If the ship sank, the debt was extinguished. Florus, through intermediaries, financed a cargo of Egyptian grain from Alexandria to Ostia. He then took out separate, secret insurance-like contracts with 3 other parties, betting against the ship's safe arrival. His masterstroke, however, was the ship itself. He owned a second, nearly identical vessel. As the first ship, the Pietas, entered the treacherous waters off Sicily, it rendezvoused with the second. By cover of night, the valuable grain cargo was transferred. The Pietas, now manned by a skeleton crew of Florus's most disposable slaves, was deliberately scuttled. The second ship, with its illicit cargo, sailed to a small, private port in Sardinia, where the grain was sold off the books. Florus then collected on the sea loans insurance provision. The lenders, believing the cargo lost, discharged the debt. He also collected on his 3 separate bets. He had multiplied his investment several times over. When rumors surfaced, the authorities were stymied. The lenders could not sue for the loan, it was legally extinguished by the loss. The purchasers of the grain in Sardinia had bought it in good faith. The scuttling was an act of damnum injuria datum, wrongful damage to property, but the property was Florus's own ship. He could, technically, do what he liked with it. The slaves who did the scuttling were, under Roman law, not competent witnesses against their master except under torture for crimes against the state, and this was a private fraud. He had created a perfect legal void. The Actio de Dolo in Re Maritima, the action concerning maritime fraud, and the Senatus Consultum on Corrupta Nautica. This was too systemic. The praetor, advised by Sulpicius, created a new action that pierced the corporate veil of maritime risk. It allowed any party defrauded in a complex maritime commercial scheme to sue the architect of the scheme for restitution, regardless of the chain of contracts or agency. It looked at the entire transaction as a single fraudulent design. More dramatically, the Senate passed a decree, the Senatus Consultum on Corrupta Nautica. It stated that the deliberate destruction of a vessel for fraudulent purpose was not mere private damage, but a crime in publicum, a crime against the public order, due to its impact on commerce and the grain supply. The master's slaves in such a case could be tortured for testimony, and if the master were convicted, his punishment was not mere fines but infamia, loss of legal standing, and exile. For the first time, commercial fraud on this scale was elevated to a public crime, creating a precedent for future laws on wider economic sabotage. The masterstroke, the litigation vortex. Having been targeted by new laws in contracts and maritime fraud, Florus embarked on his most audacious scheme. He would attack the administration of justice itself. He began a campaign of strategic, vexatious litigation. Using a network of proxies, clients, freedmen, even paupers he paid, he would file a barrage of lawsuits against mid-level senators and wealthy equites. The suits were always technically plausible but frivolous: a disputed boundary based on an archaic map, a claim to an inheritance from a distant branch of a family, a challenge to a public contract bid. His goal was not to win. His goal was to inflict the cost of defense. Under Roman procedure, a defendant faced with a lawsuit had to give personal security vademonium for his appearance in court. Missing an appointment meant forfeiture and losing the case by default. Florus would file dozens of suits against one man, scheduling hearings on the same day in different forums across the city. The defendant would be physically and financially stretched, racing between the forum, the praetor's tribunal, and the court of the centum viri. Florus's proxies would then almost always ask for postponements, dragging the process out for months. He turned the system into a weapon of economic attrition. When one target, a senator named Livius, finally snapped and publicly assaulted one of Florus's proxies, Florus had him prosecuted for injuria outrage and won a massive judgment. The system was devouring its own defenders. The edictum de tergiversatoribus et litigatoribus malitisos, the edict against vexatious litigants and procedural reforms. This was the final straw. The praetor's response was sweeping. His edict now included a chapter specifically aimed at those who twist the course of justice. The iusium juramentum judicial oath. A plaintiff could now be compelled, at the praetor's discretion or the defendant's request, to swear an oath that his suit was brought in good faith and not for the purpose of harassment or delay. Refusal meant dismissal. Security for costs. In cases deemed potentially vexatious, the praetor could require the plaintiff to post a bond quartio to cover the defendant's potential costs. Consolidation of actions. A defendant facing multiple suits from connected parties on a related matter could petition the praetor to consolidate them before a single judge. The interdictum de mirando, a new interdict injunction, allowed a magistrate to prohibit a known vexatious litigant from filing new suits without special leave, effectively making him a persona non grata in the courts. These were monumental changes. They shifted the focus from pure procedural correctness to the conduct of the litigant. They gave magistrates proactive, discretionary power to police the integrity of their own courts. Florus had forced the system to look in the mirror and create rules to prevent its own abuse. The legacy of the fox. Gaius Aquilius Florus was never convicted for his grand schemes. The new laws he inspired were used against lesser imitators. He retired, legend says, to a villa in Baiae, his wealth intact. He was the ultimate test case. His crimes were legal blueprints for chaos, demonstrating that a mind armed with perfect knowledge of a system's rules, but devoid of its ethical underpinnings, could bring that system to its knees. The laws born from his activities were more than patches. They represented a profound philosophical shift in Roman law. Times from form to substance. The Exceptio Doli series moved law away from strict formalism toward a consideration of the underlying equitable reality. Times the publicization of private fraud. The Senatus Consultum showed that large-scale economic fraud could be deemed a threat to the residential publica itself, paving the way for later concepts of financial crimes against the state. Times procedural justice. The anti-vexatious litigation edicts acknowledged that the right to sue carried a responsibility not to abuse the process, a cornerstone of modern legal ethics. Times the judge as guardian. These reforms vastly increased the discretionary, managerial role of the praetor, setting the stage for the cognitio procedure of the empire, where a state official actively investigated and decided cases. In the end, the story of Florus is the story of law's painful, necessary evolution. It is not always the sage jurist in a quiet library who shapes the codex. Sometimes, it is the brilliant, immoral fox, digging under the walls of the city, forcing the magistrates to ask not just is this legal, but what must the law become to remain just? The unwritten code of Roman honor met its match in a man who wrote his Dictionary in flawless Latin, and in doing so, compelled justice to write back. His legacy is not in the crimes he got away with, but in the thousands of pages of juristic commentary, praetorian edicts, and imperial constitutions that followed, all bearing the invisible watermark of his cunning, a permanent testament to the fact that sometimes, law advances not in spite of the criminal, but because of him. The Fox in the Henhouse, Systemic Corruption and the Republic's Response. The story of Gaius Aquilius Florus does not end with his vexatious litigation schemes. Having exposed the fault lines in private law and procedure, he turned his gaze upward, to the very machinery of the Roman state. His next series of exploits did not merely manipulate laws, they revealed how the state's own assets and offices could be weaponized through legalistic legerdemain. This phase of his career forced the Republic to confront a more existential threat, the criminal who doesn't steal from the treasury, but instead uses the treasury's rules to make the treasury itself an instrument of theft. The phantom tax farm. Rome's immense state revenues, particularly from its provinces, were not collected by a government bureaucracy but auctioned off to private syndicates of publicani tax collectors. These syndicates, often composed of wealthy equites like Florus, paid the state a lump sum for the right to collect taxes from a region, then profited by collecting more than they had paid. It was a system ripe for abuse, but governed by strict contracts lege censori issued by the censors. Florus, now leading a minor syndicate, bid for and won the contract for the salt taxes in the newly pacified region of Illyricum. The Lex Censoria was a dense document, hundreds of lines long, specifying rates, exemptions for local elites, and collection methods. Buried in a subclause on assessment of non-monetary assets was a phrase Florus had fought to insert, and where taxable goods are perishable or of a nature as to be diminished by official appraisal, the collectors may, at their discretion and for the purpose of equitable valuation, assume immediate title and custody of a representative portion for fair evaluation in Rome. Upon arrival in Illyricum, Florus's agents declared the entire first season's salt harvest, a mountainous, community-produced commodity, to be perishable and diminishing by appraisal. Invoking the clause, they assumed immediate title and custody of the entire harvest, citing the need to take it to Rome for fair evaluation. They loaded every ounce of salt onto Florus's ships and sailed away. The Illyrian communities were left with nothing. They could not pay their taxes, as the commodity with which they intended to pay had been legally confiscated. Florus then sold the salt in Sicily and Africa at a massive profit. When the outraged Illyrian chiefs and Roman provincial governor complained to the Senate, Florus was ready. He produced the contract. He had not collected a single denarius in excess of the owed tax. He had simply exercised a contractual right to secure the asset against which the tax was levied. The tax itself remained unpaid, and the communities were now in debt to the state. He coolly suggested the state might have to levy additional fines for their non-payment. The Senate was paralyzed. The censors who had issued the contract were out of office. The publicani were a powerful political bloc. Florus had not violated the contract, he had used it to perform a kind of legal alchemy, transmuting a tax farming agreement into a license for wholesale confiscation. The Lex Publicania de Bona Fide, the publican law on good faith, and the Interdictum de Re Publica. The response was twofold, reflecting the shockwaves Florus had sent through both the political and legal systems. The senatorial decree and subsequent law. The Senate, unable to break the contract, passed a senatus consultum ultimum, not the martial law version, but a final decree of advice urging the praetors to hear cases from provincials against publicani on grounds of universal good faith and the safety of the allies. This political pressure catalyzed the passage of a new lex publicania. This law mandated that all future censorial contracts with publicani contain an implicit clause of bona fides good faith in execution, and more critically, established a special, standing court quaestio to hear complaints from provincials against tax collectors. For the first time, the procedural shield of a Roman contract between the state and a publicanus could be pierced by a non-citizen provincial claiming substantive injustice. This was a radical extension of equitable principles into the realm of public administration. The praetors interdictum de re publica, the praetor Paperna, in a move of legal creativity, issued a new interdict. It stated, where a person, under color of law or contract with the state, conducts himself in a manner that threatens the peace, revenue, or good order of the republic or its allies, I will forbid that conduct. This interdictum de re publica was a preventative weapon. It allowed a magistrate, on his own authority suo imperio, to stop a legal action if its effects were tantamount to a public nuisance or threat. It was the ultimate acknowledgement that a technically legal act could be a civic crime. Florus's phantom tax farm had birthed the concept of abuse of right in public law. The ever-circulating magistrate. Having shaken the financial pillars, Florus aimed next at the political. The cursus honorum, the sequence of offices, was sacred. One of its key anti-corruption mechanisms was the rule that a man could not hold the same office twice within 10 years, and had to wait between offices. The aim was to prevent the accumulation of power. Florus saw not a barrier, but a maze to be navigated. He began a dizzying campaign of candidacies, resignations, and appointments. He would get himself elected as a quaestor financial officer. Then, before being assigned a province, he would engineer a personal crisis, a supposedly dire family obligation requiring his presence in Rome, and publicly, tearfully resign the post. The law required a replacement, but the process took time. In the interim, the Senate, needing to fill the quaestorial position for, say, the grain supply in Ostia, would often appoint a temporary replacement from among those already in Rome who had magisterial experience. Florus, having just been a quaestor, was a prime candidate. He would be appointed as proquaestor acting quaestor to the very post he had just resigned. He now held the same functional power, but under a different title, thus skirting the spirit of the ban on successive offices. He did this not once, but in a cycle: quaestor, resign, proquaestor. Then, he'd get elected as aedile, resign, and get appointed as prodile to oversee a specific festival or building project. He was a perpetual magistrate, never in violation of the letter of the cursus honorum, but constantly in a position of official power and its attendant opportunities for graft, influence peddling, and the skimming of public funds. He became a bureaucratic perpetual motion machine, generating the aura and authority of office without the electoral accountability. The lex annalis minutia, the Minutian law on years, and the senatus consultum de magistratibus gerendis. Florus's carousel of offices exposed a glaring oversight. The laws regulated election and tenure, but not resignation and reappointment. The Senate, horrified by this living loophole, acted. The lex annalis minutia, this law amended the existing leges annals. It now stipulated that any magistrate who resigned his office voluntarily was ineligible for any other curial, elected, or appointed magistracy for the full original term of the office he had abandoned. If you resigned a quaestorship one-year term, you were barred from any other official post for the next year. Resignation was no longer an exit, it was a self-imposed political exile for the duration. The law framed it as a matter of public duty. Accepting office was a contract with the Roman people, and willful breach carried a penalty. The Senatus Consultum de Magistratibus Gerendis, this decree tackled the appointment side. It forbade the Senate from appointing any individual to a temporary or acting magistracy pro magistratu if that individual had held any elected magistracy within the preceding 2 years. It severed the link Florus had exploited. The pool for temporary appointments was now restricted to former magistrates who had been out of office long enough to be considered disinterested replacements, not immediate self-successors. These were profound changes. They transformed resignation from a private right into a public act with severe consequences. They also reinforced the principle that magistracies were discrete, bounded periods of service, not a fungible continuum of power. Florus had forced the Republic to define what it meant to hold office, not just to win it. The hostage fortune. Florus's final, and perhaps most psychologically astute, manipulation targeted the very bedrock of Roman society, the family and its wealth. Roman law had intricate rules of tutelar guardianship for women and minors, and patria potestas, the father's power over sons. A paterfamilias had near absolute control over the family estate. Florus devised a scheme that turned these protective and patriarchal institutions into prisons. He would identify wealthy, aging patres familias with a single, beloved daughter heir or a young son under his power. Through friendly loans and business dealings, he would ingratiate himself. Then, he would propose a brilliant estate preservation strategy. He would draw up a contract for a fiducia, a trust-like arrangement. The father would formally sell the entire family estate to Florus for a nominal sum. The fiducia agreement, a separate document, stipulated that Florus held the property in trust, would manage it wisely, and upon the father's death, would transfer it directly to the daughter or son, bypassing any potential political threats or predatory creditors. It was marketed as a shield against prescription or confiscation in turbulent times. The fathers, fearing for their family's future, often agreed. The legal transfer of title was flawless. Once the fiducia was signed and the sale complete, Florus's demeanor would change. He was now the legal owner. He would begin to bleed the estate, selling off choice lands, calling in the family's loans at ruinous rates, and leasing properties to brutal tenants. The father, now a mere beneficiary of a trust he could not control, was helpless. If he protested, Florus would produce the sale contract. He was the owner, exercising his rights. The fiducia agreement was a private promise, but its enforcement relied on Florus's good faith, which had now vanished. To sue would be long, expensive, and would publicly expose the father's folly. Many chose silent ruin. Florus held their fortunes hostage, with the law as his ransom note. The actio fiducii and the courtio legata. This abuse struck at the Roman soul, the integrity of the family and the orderly transmission of property. The legal response was swift and sophisticated, creating entirely new realms of obligation. The actio fiducii action on the trust. The praetor, perhaps most outraged by this betrayal of intimate confidence, created a powerful new good faith action. The actio fiducii was not about the property title dominium, which was clearly Florus's. It was about the breach of the confidential relationship fiducia itself. It allowed the injured party, the father or heir, to sue for not just restitution of the property's value, but for double damages as a penalty for the breach of trust. For the first time, Roman law explicitly recognized and protected the beneficial interest separate from the legal title, a cornerstone of modern trust law. It sent a message: some agreements are more sacred than others because of the relationship they are based upon. The courtio legata, the legacy bond. Furthermore, in response to the specific fear of estate predation, a new procedural rule emerged. In any fiducia or similar deathbed transfer designed to circumvent normal inheritance, the praetor could require the trustee like Florus to post a massive security bond courtio with a public depository, guaranteeing his performance. Failure to adhere to the terms of the trust resulted in automatic forfeiture of the bond to the heirs. This turned a moral obligation into a financially enforced one. The unindicted architect. By the end of this second wave of schemes, Gaius Aquilius Florus was the most notorious legal mind in Rome, and still, technically, unconvicted. He was a living specter in the law courts, a cautionary tale cited by advocates and jurists. "Are you suggesting I am a Florus?" became a standard rhetorical rebuke against overly clever legal arguments. His legacy was now etched deep into the Republic's legal and political fabric. He had forced the creation of times public law equity, the principle that state contracts must serve the public good, not just formal correctness. Times the non-fungibility of office, the idea that public authority could not be gained through semantic title changes. Times the sanctity of fiduciary duty, the legal elevation of confidential relationships to a protected status. The Roman state had, in effect, been engaged in a frantic, multi-year dialogue with its most brilliant enemy. Every new edict, senatorial decree, and law was a response to his last argument. He was the ultimate stress test. The Republic, in its late, volatile years, was proving it could still adapt, could still use its legal genius to patch the holes torn by a criminal genius. But Florus was not done. The final act of his career would not target a law, a contract, or an office. It would target the most powerful force in the late Republic, a Roman general at the head of a loyal army. He was about to move from exploiting systems to exploiting men, and in doing so, would force the creation of the most dangerous and enduring law of all. The fox was leaving the henhouse and heading for the lion's den. The lion's share, corrupting glory and the birth of treason. The legal innovations spurred by Gaius Aquilius Florus had fortified private contracts, public administration, and political procedure. Yet, a realm of Roman life remained, one governed more by custom, glory, and raw power than by statute, the military. Here, the mos maiorum, the way of the ancestors, and the sacred bond between commander imperator and legionary were paramount. It was a world Florus had avoided, until the scent of unparalleled profit drew him in. His final, most audacious scheme would not merely bend laws, it would attempt to corrupt the very source of Roman strength, forcing the state to define a crime it had never before needed to name so precisely: treason against the army itself. The spoils of a phantom victory. The year was 61 BCE. The famed General Gnaeus Pompeius Magnus Pompey the Great was concluding his monumental campaign against the pirates and King Mithridates in the east. Back in Rome, anticipation of his return, and the unimaginable wealth of spoils, tribute, and slaves he would bring, was the sole topic of conversation. The financial markets buzzed. Creditors waited to be repaid, speculators jockeyed to buy the incoming plunder at wholesale prices, and the treasury salivated at its share. Florus saw his opportunity not in stealing from Pompey, but in becoming his financial shadow. He understood two things. First, that the logistical challenge of transporting and liquidating a vast, multinational hoard of treasure, art, and human captives was beyond the scope of even a great general staff. Second, he knew that Pompey, obsessed with his public image and political future, would be deeply sensitive to any scandal or mismanagement that could tarnish his triumph. Florus assembled a consortium of the most discreet and ruthless equites and formed Societas Acquisitionis Orientalis, the Eastern Acquisition Society. He did not approach Pompey directly. Instead, he deployed a network of agents to the ports of Asia Minor, Greece, and Illyricum, the routes Pompey's convoys would take. His agents, posing as official quartermasters or accredited buyers for the treasury, would meet Pompey's junior officers and tribunes. Their offer was seductively simple: the general is burdened with the cares of victory and politics. We offer immediate liquidity. Sell us this contingent of slaves now, at a 20% discount off their projected Rome price. You get hard cash for the legion's donative and expenses immediately, without the delay and risk of the long voyage. The general is spared the administrative headache. It's a victory for all. To sweeten the deal, Florus's agents offered personal gratuities to the officers facilitating the sales, not as crude bribes, but as commissions for expedited logistics. They began buying up portions of Pompey's spoils in transit, piece by piece. Florus's ships, not Rome's, carried the assets. His warehouses, not the state's, held them. But Florus's scheme had a darker layer. He also began to short-sell the very assets he was buying. He would contract to sell, for future delivery in Rome, vast quantities of Eastern grain, Armenian bronze, and enslaved captives at today's high prices, betting that the market would be flooded and prices would crash when Pompey's full haul finally arrived. He was simultaneously cornering the market on the spoils and betting against their value, a self-fulfilling prophecy of profit. The crisis erupted when a sharp-witted quaestor in charge of Pompey's treasury, one Marcus Aemilius Lepidus, noticed discrepancies. Shipments of silver from Pontus were logged as lost to storm, but Florus's agents were later seen selling distinctive Pontic bullion in Thessalonica. A ledger showed 1,000 Cilician slaves sold to official agents, but the state had no record of the payment. Lepidus investigated and uncovered the web. He confronted a tribune who had dealt with Florus's men. The tribune, panicked, confessed to taking the commission, insisting he believed the agents were legitimate. Pompey was livid. This was not just theft, it was an insult to his dignities, a leeching of his hard-won glory into the pockets of a financier. It made his army look corrupt and his triumph potentially less spectacular. Yet, when Pompey's lawyers looked for a charge, they were stymied. Florus had not stolen from the state. The spoils, until formally deposited in the treasury, were arguably under the general's imperium. The sales, while unethical, were transactions between Pompey's officers with questionable authority and Florus who claimed good faith belief in their authority. The short selling was simply shrewd market speculation. He had created a legal gray zone between military command and private commerce, profiting from the ambiguity. The Lex Cornelia de Peculiatu Exercitus, the Cornelian law on embezzlement from the army, and the Senatus Consultum de Majestate Exercitus. The fallout was immense. Pompey, his political clout at its peak, demanded action. The Senate, terrified of alienating its most powerful general, complied with groundbreaking legislation. The Lex Cornelia de Peculiatu Exercitus, sponsored by a consul friendly to Pompey, this law created a new capital crime. It defined peculiatus exercitus army embezzlement as the fraudulent diversion, conversion, or unauthorized acquisition of any property, captive, or monetary asset belonging to the Roman people, which is in the custody, possession, or under the command imperium of a general of the Roman people in the field, whether such asset has been formally inventoried for the treasury or not. Scope: it covered the entire chain of custody, from battlefield to treasury door. Liability: it criminalized not only the taker but anyone who knowingly aids, abets, or receives such property. Florus's good faith belief defense was nullified. Penalty: the penalty was death interdiction from fire and water and the full confiscation of the perpetrator's estate. The law treated the crime as a furtum theft from the entire Roman people, aggravated by its betrayal of the military. The Senatus Consultum de Majestate Exercitus, accompanying the law, was a monumental Senate decree, the decree on the majesty of the army. It stated that any action which diminishes the loyalty of the soldier, corrupts the officer, or impairs the efficiency and morale of the armies of the Roman people, was an attack on the Maesta's majesty sovereignty of Rome itself. This was a conceptual leap. It explicitly linked the army's internal integrity to the security of the state. Florus's corruption of officers was now framed not as simple bribery, but as a subversion of a fundamental institution. This decree provided the philosophical underpinning for later, broader laws of treason maestas under the empire. Florus, for the first time, faced genuine peril. The new law was retroactive in its spirit, if not its letter. Pompey's faction was baying for his blood. Yet, the fox had one last, brilliant retreat prepared. The citizen's shield. Cornered by the new army embezzlement law, Florus did not flee or beg. He executed a pre-planned legal defense so audacious it turned the tables on his accusers. He publicly announced that he was exercising his right, as a Roman citizen, to populum provocationem, an appeal to the people's assembly against a capital sentence imposed by a magistrate. This ancient right, dating to the Leges Valerii, was a cornerstone of republican liberty, designed to protect citizens from arbitrary patrician power. But Florus corrupted its intent. He used his vast wealth to flood the assembly with propaganda. He hired plebeian orators to frame the issue not as theft from Pompey, but as Pompey's envy of a free citizen's wealth. Pompey Magnus returns from the east, thinks himself a king, and now wants to seize the lawfully acquired property of a Roman knight, his spokesman cried. Is this why we fought the kings? So one general can use new, hastily made laws to devour his fellow citizens. He painted himself as the victim of an overmighty general abusing the judicial process for personal vengeance. He then made a breathtaking public offer. He declared he would submit all disputed transactions to a panel of neutral, esteemed former consuls for arbitration. If they found he had acted in bad faith, he would repay triple the value to the treasury. But, he demanded, all charges must be dropped first. It was an offer designed to be refused, making his enemies look unreasonable. The strategy was diabolically effective. It politicized the trial completely. Popular politicians, always suspicious of the senatorial oligarchy and powerful generals, saw utility in defending Florus as a stick with which to beat Pompey and the Senate. The legal question was drowned in a roar of political factionalism. The assembly grew deadlocked. The result: the Lex Iulia Divi Publica, the Julian law on public force, and the Formula de Pervertin Judicia. Florus's manipulation of the popular assembly was the last straw. It showed how the Republic's own sacred rights could be weaponized to obstruct justice. The response, led by a coalition of exasperated senators from both conservative and popular factions, aimed to fortify the judicial process itself. The Lex Iulia Divi Publica. This law, a precursor to later Augustan legislation, criminalized the use of wealth, mobs, or public clamor to pervert the due course of public justice. Specifically, it forbade systematically inciting the multitude, by pecuniary reward or false rhetoric, for the purpose of influencing a judicial vote, intimidating witnesses, or delaying the lawful judgment of a constituted court. For the first time, jury tampering and the orchestrated perversion of a public trial were defined as crimes of vis public force violence, even if no physical violence occurred. The law aimed to protect the dignitaries of the courts from the very democratic pressure that had once been their safeguard. The praetor's Formula de Pervertin Judicia. The praetor added a new clause to the legal formula given to judges in complex cases. It allowed a judge, upon clear evidence, to find a litigant guilty of abuse of process before ruling on the main case, resulting in immediate forfeiture and a judgment against them. It was a procedural kill switch for exactly Florus's brand of theatrical, democracy-paralyzing defense. The final silence and the unseen legacy. Facing this new battery of laws, and with political winds shifting against him as Pompey and his enemy-turned-ally Crassus found common ground in their disdain for him, Gaius Aquilius Florus did the one thing one expected: he vanished. Not through flight, but through silence. He settled all outstanding claims in the arbitration panel, which he finally allowed to proceed, paying a massive but not ruinous sum to the treasury. He then withdrew entirely from public life. He sold his house on the Palatine, dissolved his societates, and retired to a modest, unassuming villa in the hills of Sabinum, far from Rome. He gave up the law, commerce, and politics entirely. He became a philosopher-farmer, writing obscure and now lost treatises on geometry and horticulture. The fox had dug one last, deep earth and pulled it in after him. His legacy, however, was anything but silent. The laws he forced into existence formed a new stratum of Roman jurisprudence. The criminalization of systemic fraud, from maritime sabotage to army embezzlement, his actions pushed Roman law to see interconnected, non-violent schemes as crimes against public order. Times the fiduciary revolution, his abuse of trust created legal tools that recognized and protected dependent relationships, laying the groundwork for modern fiduciary law. Times procedure as substance, he proved that how one used the courts could be as dangerous as the crime itself, leading to laws protecting judicial integrity from financial and mob influence. Times the army as a legal entity, his greatest, unintended contribution was the legal conceptualization of the army not just as a force, but as an institution whose internal corruption was a maestas issue, a direct precursor to the later imperial laws of treason. The ghost in the Codex. Centuries later, in the great compilation of Emperor Justinian, the Digest and Institutes, the name Gaius Aquilius Florus appears nowhere. His scandals are forgotten. But the legal principles born from his cunning are everywhere, anonymized and immortalized. When the jurist Ulpian writes, "Ius est ars boni et equi law is the art of the good and the fair," he is echoing the corrective force unleashed to counter Florus's sterile formalism. When the Digest discusses the exceptio doli, the actio fiduciae, or the crimes of peculatus and maestas, it is citing doctrines that were hardened in the fire of his schemes. He was the ultimate adversarial genius. The Roman legal system, in its relentless, pragmatic brilliance, did not defeat him in a trial. It did something far more profound. It metabolized him. It studied his poison and created an antidote, not just for him, but for all who would come after. He was the criminal so smart he became, unwittingly and unwillingly, one of Rome's greatest legal reformers. The law he spent his life outwitting became stronger, more nuanced, and more just because it had to contend with the likes of him. In the end, the unwritten code of Roman honor wrote itself anew, and the signature on that monumental work, invisible but indelible, was that of the fox. The echo in the marble, legacy, memory, and the afterlife of a ghost. The final withdrawal of Gaius Aquilius Florus into rural obscurity was not an end, but a transposition. He moved from the noisy, sweaty forum of legal combat to the quiet, enduring medium of influence. The man vanished, the precedent remained, pulsing like a buried current beneath the stone of Roman law. His story, though scrubbed from official annals by a combination of shame and political expediency, lived on in the corridors of power and the minds of those who shaped the Republic's final century and the empire that followed. The ghost in the machine, Florus in the late Republic. In the turbulent decades after Florus's disappearance, his specter haunted every ambitious schemer and wary legislator. For the criminal underworld, his methods became a dark syllabus. Ambitious fraudsters studied not just the laws, but the edicta and senatus consulta of the Floran era, searching for the next unpatched seam in the legal fabric. A cottage industry of forensic consultants emerged, shady jurists who, for a fee, would design contracts with Floran clauses, testing the new exceptio doli and actio fiduciae to their limits. His career proved that the highest profits lay not in defying the law, but in wearing its skin. For the Senate and praetors, Florus became a rhetorical shorthand and a permanent caution. Debates on new legislation would inevitably feature a weary senator asking, "Yes, but what would a Florus do with this?" His name was invoked to justify preemptive legal precision, often leading to laws that were more complex, more restrictive, and sometimes regrettably rigid. The drive to close every possible loophole began to stifle the very flexibility that had made the praetor's edict so vital. In trying to outlaw genius-level malice, they risked outlawing innovation itself. Most tellingly, he influenced the rise of Cicero. The young Marcus Tullius Cicero, building his reputation as a lawyer in the 70s and 60s BCE, cut his teeth on cases involving intricate financial fraud and inheritance disputes, the very world Florus had polluted. Cicero's entire philosophical project, the elevation of natural law ius naturale over mere civil statute ius civile, can be seen as a direct intellectual response to the Floran phenomenon. For Cicero, Florus was the embodiment of what happened when civic virtue virtus and good faith bona fides were divorced from legal brilliance. Cicero's arguments in cases like Pro Rotio Commoedo or his treatise De Officiis on duties constantly stress that legality is not morality, that a true Roman acts not just within the letter of the law, but according to an inherent higher justice. This was the philosophical fortification against the next Florus. The Principate's inheritance, systematizing the anti-Florus. When the Republic collapsed into the autocracy of Augustus, the legal legacy of Florus was not discarded, it was systematized and weaponized. The emperor, needing stability above all else, could not tolerate such a destabilizing, individual force. Augustus, the master restorer, absorbed the lessons perfectly. His monumental legislative program, the Julian laws on public order, adultery, and extortion, took the reactive, Floran-inspired statutes and wove them into a coherent, top-down system of social control. The Lex Aelia Divii Publica, born from Florus's manipulation of the assemblies, became a tool for the princeps to suppress any form of organized political opposition, labeling it as public violence. The concept of maesta's majesty, which the Senate had expanded to protect the army's integrity, was now transformed by Augustus and his successors into the crime of lesa maestas, injured majesty, an elastic charge that could snare anyone perceived as disloyal to the person of the emperor. Florus had shown how to attack systems. The emperors ensured that the ultimate system, the imperial state, was legally unassailable. The role of the praetor fundamentally changed. The creative, equity-driven ius honorarium that had evolved to catch Florus began to freeze. The emperor's decrees and the opinions of his salaried jurists like Gaius, Ulpian, and Papinian became the primary source of law. The dynamic, year-by-year dialogue between criminal and praetor was over. Justice was now administered from a throne, not a tribunal. The fox had proven the republic's legal agility. The lion, the emperor, replaced it with immutable strength. Of 2nd to 3rd century CE, the great jurists faced a conundrum. The legal tools they relied upon, the sophisticated actions on fraud, trust, and good faith, had been sharpened in a fight against a notorious criminal. How does one cite the precedent without honoring the man? The solution was elegant: erasure and attribution. Florus's name was meticulously omitted. Instead, credit for the legal innovations was given to the respectable statesmen and jurists who had crafted the responses. The exceptio doli was discussed in the context of the wise praetor Servius Sulpicius Rufus. The actio fiduciae was a testament to the praetorian commitment to equity. The crime of peculatus was a necessary defense of public property, its origins blurred. Yet, the ghost lingered in the hypotheticals. The juris digesta and responsa are filled with elaborate, often bizarre hypothetical cases used to test legal principles. If a man sells the same slave twice, if a ship's captain throws cargo overboard fraudulently, if a guardian wastes a ward's estate through cunning investments, these were not mere academic exercises. They were stress tests, and the original stressor was the memory of schemes so ingenious they had forced the law to reinvent itself. The jurists, in their quiet studies, were still playing a game of chess against Florus's shadow, ensuring the board had no more unchecked squares. The Christian Empire and the Final Judgment. With the advent of Christianity as the state religion, a new moral lens was applied to law. The Emperor Justinian's great codification in the 6th century CE sought to harmonize Roman law with Christian ethics. In this final synthesis, the legacy of Florus undergoes its most fascinating transformation. The Corpus Iuris Civilis enshrines all the Floran-inspired doctrines, but baptizes them in a new spirit. The preface to the Digest speaks of law as a gift from God for the governance of mankind. Fraud dolus, bad faith mala fides, and the violation of trust are now not just civil wrongs or public offenses, but sins. They are transgressions against a divine order as well as a temporal one. Florus's career, a life dedicated to exploiting the letter of the law while utterly violating its spirit, becomes, in the Christian Roman worldview, the ultimate parable of legalism versus justice. He is the Pharisee of Roman law, meticulously tithing mint and cumin while neglecting the weightier matters of the law: justice, mercy, and good faith. The robust apparatus built to contain him is now presented as evidence of the law's inherent pursuit of a higher, God-given equity. In the Institutes of Justinian, the student is taught, "Uis precepta sunt hic, honest viva, altrum non ladia, suum quic tribua." The precepts of the law are these: to live honestly, to injure no one, to give each his due. This trinity is the philosophical annihilation of Florus's entire life's work. He lived dishonestly in a technical honesty, he injured everyone through non-violent means, he took what was not his due through a forest of contracts. Justinian's code is the tomb, and this maxim is the epitaph, for the Floran way of life. Epilogue: the man who was a precedent. So, what remains of Gaius Aquilius Florus? He left no dynasty. No great building bore his name. His philosophical works on geometry are dust. He exists in history only as a negative space, an imprint. He was the ultimate adversarial contributor. In every field, medicine, technology, warfare, progress is often driven by conflict, by a problem that must be solved. Florus was the human embodiment of a catastrophic, legal problem. The Roman state, in its pragmatic genius, did not simply execute the problem, it solved it, and in solving it, advanced the entire science of law. He proved that a legal system cannot survive on precedent and procedure alone. It needs a living, breathing equity, a conscience. He forced the bona fides from a vague ideal into an actionable, legal standard. He demonstrated that certain relationships, soldier and general, citizen and state, trustee and beneficiary, are so fundamental that their betrayal constitutes a crime against the Commonwealth itself. In the end, the story of Florus is not a crime story. It is a creation story. It is about how the relentless pressure of one brilliant, corrosive intelligence acted as a geological force, compressing the soft sediments of custom and statute into the hard marble of classical law. The laws that only existed because he was too smart became the very bones of the Western legal tradition. When a modern court pierces a corporate veil, invokes equity to prevent an unjust enrichment, or prosecutes a complex financial fraud, it is speaking a language whose grammar was solidified in the Roman Forum, in a long, silent duel between a fox and an empire. He sought to prove that law was a game for the clever. He succeeded only in proving it was a fortress for the just, a fortress whose every hidden gate and reinforced wall was built because he had once shown them how to break in. His legacy is the unbreachable wall, his monument, the justice it protects. The ghost in the Codex had, at last, been made to serve the common good. The long shadow, Florus in the medieval mind and the modern echo. The physical collapse of the Western Roman Empire did not bury the legal legacy of Gaius Aquilius Florus. Like a hardy, tenacious rhizome, the principles forged in opposition to his cunning survived the Dark Ages, pushing shoots through the crust of Germanic customary law and canon law to re-emerge, transformed yet recognizable, in the medieval and modern worlds. His ghost did not haunt a single codex, it haunted the very idea of law itself. The Dark Age interregnum, a principle in hibernation. In the fragmented kingdoms of the post-Roman West, the sophisticated, written ius civile gave way to oral, tribal customs, compurgation, trial by ordeal, wergild. The Floran model of hyperliterate, procedural fraud seemed a relic of a dead, overcomplex civilization. Yet, his core legacy, the danger of bad faith within formal agreements, found a new home where one might least expect it, in the church. Canon law, developing from the 6th century onward, faced its own Floran problems. What was to be done with the sinner who exploited the letter of church law to violate its spirit? The cleric who used a technicality to seize land from widows? The penitent who parsed the terms of penance to avoid true contrition? The church fathers and later canon lawyers turned instinctively to the Roman concepts preserved in fragments and digests. The maxim fides et ratio, faith and reason, though having theological roots, took on a legal dimension. Fides here echoed the Roman bona fides, a demand for intrinsic honesty that transcended literal obedience. The canonists, like Gratian in his Decretum c. 1140, explicitly resurrected Roman equitable principles to combat fraudulent circumvention fraus legis. They cited, often without knowing the original context, the very ideas born to trap Florus, that a trust is sacred, that an agreement must be interpreted in good faith, that an action lawful on its face can be sinful in its intent. Florus's secular crimes became, in the medieval mind, archetypes of sinfulness, the sin of cavillation, of using cleverness to evade moral duty. The rebirth, ius commune and the Scholastiligi. The 12th century Renaissance and the rediscovery of Justinian's Digest in its full glory brought Florus's legacy roaring back to life. At the University of Bologna, the glossators and later the commentators like Bartolus de Saxoferrato and Baldus de Ubaldus didn't just study Roman law, they wrestled with its contradictions and its brilliant solutions. In their commentaries, the hypotheticals became more elaborate, the puzzles more fiendish. And in these academic disputations, a spectre took shape. They gave him a name, fraus legis, the fraud upon the law. He was no longer a historical individual but a jurisprudential archetype, a personified legal principle of evil. The scholars debated fraus legis endlessly. Could one avoid a statute by technically adhering to its words while gutting its purpose? Florus's phantom tax farm. Could a condition in a will or contract, though literally fulfilled, be voided for bad faith? Florus's hostage fortune. The ius commune, the common law of Europe based on Roman canonical principles, was built, in part, on the answers to these questions. The maxim fraus omnia corrumpit, fraud corrupts everything, became a bedrock principle. It meant any legal act, however perfect in form, was vitiated by fraudulent intent. This was the exceptio doli writ large, universalized, and given metaphysical weight. The medieval lawyer, steeped in scholastic logic, had turned the memory of a Roman criminal into a first principle of legal metaphysics. The common law's distant cousin, equity's separate birth. While the continent embraced the Roman-derived ius commune, England took a different path, developing its own common law. Yet, the Floran problem manifested there with equal force. The English common law of the late medieval period became just as rigid, formalistic, and obsessed with writs and forms as the early ius civile had been. The result was the same. Clever manipulators could use the strict forms to commit grievous injustices. The English solution was not to infuse the common law with bona fides, but to create a parallel system, the Court of Chancery, administering equity. When a subject petitioned the king and later the Lord Chancellor for justice beyond the rigid common law, they were often pleading against a Florus. The chancellors, many of them churchmen trained in Roman and canon law, explicitly invoked principles of conscience. They issued injunctions to stop someone from enforcing a technically valid but unconscionable judgment. They enforced uses the early English trust against corrupt fefis who tried to keep the property for themselves, a direct echo of the Actio Fiducia. The great legal historian F.W. Maitland noted that equity was a gloss on the common law, but it was a gloss written in the same ink the Roman praetors had used. The Lord Chancellor's conscience was the functional descendant of the praetors equites. Though arriving at similar outcomes through different procedural means, both systems were answering the same eternal challenge: what to do when the law, as written, becomes an engine of wrong? Florus was the timeless proof that such a challenge was inevitable. The modern metamorphosis, from Fox to framework. In the modern era, the Floran archetype has fragmented and multiplied, embedded in the foundations of commercial and international law. The corporate veil and fiduciary duty. The modern corporation, a legal person, is the ultimate Floran playground, a realm of limited liability, complex agency, and opaque transactions. The legal response has been the doctrine of piercing the corporate veil and the immense body of law on fiduciary duty. When directors or majority shareholders use the corporate form to commit fraud, strip assets, or cheat creditors, courts will look past the legal fiction to the real party in interest. This is the direct conceptual descendant of the praetor looking past Florus's web of proxies and contracts to the man pulling the strings. The modern fiduciary duty of care and loyalty, owed by corporate officers to their shareholders, is the great-grandchild of the Actio Fiducii born to stop Florus from looting family estates. The regulatory state and spirit of the law. The 20th century saw the rise of the administrative and regulatory state, governing everything from securities to the environment. In response, a new breed of Florus emerged: the company that finds the regulatory loophole to dump toxins, or the financier who designs a complex derivative that skirts banking laws. The legal counterattack has been the proliferation of catch-all regulations like the U.S. Securities and Exchange Commission's Rule 10b-5 against any device, scheme, or artifice to defraud, and the principle of interpreting regulations according to their spirit and purpose. Anti-avoidance doctrines in tax law explicitly empower authorities to ignore transactions that have no commercial purpose other than tax reduction. This is the Exceptio Doli and the Senator's Consultum on Corrupta Nautica reborn for the age of global finance. The abuse of right in international law. On the global stage, the Floran problem manifests when a sovereign state uses its legal rights under international treaties to cause harm. The principle of abus de droit, abuse of right in international law, holds that a state cannot exercise a right for the sole purpose of causing injury to another state. This doctrine, debated in cases of environmental damage, economic coercion, and cyber warfare, is the internationalization of the same idea, that legal power, divorced from good faith, becomes a weapon. It is the ghost of Florus's vexatious litigation and phantom tax farms, now haunting the chambers of the International Court of Justice. The enduring paradox: law's necessary adversary. So, what is the final assessment of Gaius Aquilius Florus? He represents a profound and enduring paradox: the criminal as catalyst. He was the ultimate stress tester. Every complex system, to remain robust, needs to be tested to the point of failure. Florus was the living, breathing failure mode of Republican law. He didn't just find weaknesses, he designed elaborate proofs of concept for how they could be catastrophically exploited. The Roman state, in its pragmatic glory, treated his crimes not merely as offenses to be punished, but as bug reports to be patched. Each new edict, law, and decree was a system update. This creates a troubling, almost heroic, narrative arc for the villain. In mythology, the hero needs a monster to slay. In legal evolution, justice needs a brilliant injustice to overcome. Florus, in this light, becomes a dark, unwilling patron saint of jurisprudence. He is the trickster god of the legal order, Loki, Anansi, Coyote, whose mischief, though destructive, forces the gods to become wiser, stronger, and more just. His legacy whispers a perpetual warning to lawmakers: you are not as smart as the smartest person who wants to break your rules. It is a warning against complacency, against believing a code is complete. It is an argument for preserving discretionary equity, the praetor's power, the chancellor's conscience, the judge's sense of justice, within any legal system, as an essential immune response against the mutating virus of human cunning. The name that is not spoken. Today, in the hushed reading rooms of law schools and the bustling floors of financial regulatory agencies, no one speaks the name Gaius Aquilius Florus. His victory was total and his defeat absolute. He won immortality, but only as a set of problems. He achieved lasting fame, but only as an absence, a negative space defined by the positive structures built to contain him. He is present in the attorney's instinct to ask, "What's the catch?" in the drafter's fear of an ambiguous clause, in the judge's squint at a too-perfect technicality. He is the reason contracts have good faith and fair dealing implied terms. He is the reason trusts are enforceable. He is the reason fraud is a tort, a crime, and a defense. He is in the end the most successful failure in legal history. A man who set out to prove the law was a game for the clever, and proved instead that it was a living, adaptive organism that could learn, grow, and out-evolve even its most brilliant parasite. The laws that only existed because he was too smart are now the laws that ensure no one can ever be that smart again. The fox's den is empty, but the forest is now full of guardians he himself taught how to see in the dark. The immortal precedent, a tomb, a seed, and the unwritten epilogue. The story of Gaius Aquilius Florus has no dramatic final trial, no climactic suicide on his sword, no poetic exile on a windswept rock. His end was a whisper, a deliberate and meticulous erasure. Yet, this quiet disappearance was perhaps his final, most instructive masterstroke. He demonstrated that the ultimate evasion is not to escape punishment, but to escape definition, to become not a man, but a condition, not a criminal, but a catalyst. His final lesson to Rome was that the most dangerous adversary is not the one who breaks the law, but the one who becomes indistinguishable from its logic. Retirement as the ultimate checkmate. Consider his retirement. After settling the Pompey affair with a calculated, non-ruinous payment, he did not flee to some luxurious villa in Baiae to gloat. He chose a modest farm in Sabinum, the heartland of old Roman virtue. He did not write memoirs, which would have been a form of engagement, a continued duel. He wrote instead on geometry and horticulture, disciplines of pure, abstract logic and patient, organic growth. It was the ultimate dissimulation, the architect of legal chaos posing as a rustic sage. In doing so, he performed a final, brilliant manipulation of Roman social physics. He understood that in the late Republic, infamia disgrace and gloria glory were two sides of the same coin of notoriety. By disappearing, he denied the state the satisfaction of his disgrace. He denied his enemies the focus of their hatred. He denied history a clean, moralizing ending. He simply stopped being a player, and in doing so, he froze his legacy in a state of perpetual potential. He became a ghost in the machine, a what-if that never received a definitive answer. This unresolved tension is what gave his influence such lasting power. The law had been updated to counter his known schemes, but the genius that devised them was still out there, silent, thinking. What might he think of next? The paranoia he left behind was more potent than any punishment. Tomb of marble and text, Justinian's codification as exorcism. Centuries later, the Emperor Justinian's monumental effort to codify all Roman law can be seen, in part, as the final attempt to exorcise the Floran spirit. The Corpus Iuris Civilis was not just a compilation, it was a closure. By gathering the responsa of the jurists, the edicts of the praetors, and the decrees of the emperors, and stamping them with imperial authority, Justinian sought to end the dynamic, evolutionary conversation that had characterized Roman law. He aimed to create a complete, static, and authoritative system. In this sealed tomb, the tools forged against Florus were given their final, polished form. The exceptio doli was no longer a praetor's annual experiment, it was law. The actio fiduciae was no longer a novel remedy, it was a standard entry. The crime of peculatus was enshrined. By making these principles immutable, Justinian was trying to say, the debate is over. The loopholes are closed. The fox is dead, and his tricks are now merely paragraphs in our book. But in sealing the tomb, he also mummified the body, preserving it perfectly for later ages to discover. The medieval scholars who pored over the digest weren't just reading law, they were conducting an autopsy on the legal system that had defeated, and been shaped by, its most ingenious enemy. They found the scars and studied the surgeries. The Floran influence, anonymized and institutionalized, was thereby guaranteed immortality. He achieved through the empire's desire for order what he could not through his own schemes, a permanent, foundational place in the Western legal tradition. The seed in the cracks, why his story resonates. Why does this figure, absent from history books, feel so compelling, so strangely modern? Because Gaius Aquilius Florus is not a historical anomaly, he is a human constant. He represents the dark edge of intelligence applied to systems. In every age, he has new names. Times in the Renaissance, he is the scheming courtier manipulating patronage laws. Times in the 19th century, he is the robber baron using corporate charters to build monopolies. Times in the 20th century, he is the hostile takeover artist using leveraged buyouts and poison pills. Times in the 21st century, he is the algorithmic trader exploiting microsecond latency arbitrage, the tax strategist designing labyrinthine offshore vehicles, the social media manipulator using terms of service loopholes to spread disinformation. His essence is the being who looks at a rulebook and sees not instructions, but a puzzle to be solved for personal gain. His eternal question is, what does the system allow, not what does it intend? This is why his story transcends Rome. It is the perpetual arms race between structure and ingenuity, between the architects of order and the engineers of chaos. The unwritten epilogue, the lesson for the forum of the world. The final, unwritten chapter of Florus's legacy is not in a law library, but in the ongoing project of human civilization. His story offers three stark lessons for any society that governs itself by rules. The necessity of equity. A legal system built solely on bright-line rules and strict procedure will inevitably become a prison for the weak and a playground for the strong and clever. It must contain within it a living principle of fairness, a bona fides, a chancellor's conscience, a judge's discretion, that can look beyond the form to the substance. This principle is not a weakness, it is the system's immune system. The virtue of the adversary. While we cannot celebrate the criminal, we must, ironically, respect the function of the ultimate adversary. The Florus of any age is a hostile auditor. He performs a cruel but vital service by stress-testing the system to its breaking point, revealing flaws before they can be exploited at a catastrophic scale. A society that silences or ignores its most clever critics, even the immoral ones, does so at its peril. It is often the villain who shows the hero where his armor is weak. The humility of law. The most profound lesson is one of humility. The Roman jurists, for all their brilliance, did not foresee Florus. They built a magnificent edifice, and he found the hidden flaws in the foundation. This should forever caution us against legal triumphalism, against believing any code is final, complete, or perfectly just. Law is a living language in a constant dialogue with human ingenuity, both noble and corrupt. The work of justice is never finished because the imagination of injustice is never exhausted. The name on the wind. So, let us return to the beginning, ancient Rome laws that only existed because one criminal was too smart. We have followed the thread from the forum to the farm, from the Senate floor to the imperial codex, and into the modern world. We have seen that these laws were not mere reactions, they were evolutionary adaptations. They were Rome learning, in real time, how to be more just by understanding the mechanics of injustice. Gaius Aquilius Florus, the man, dissolved into the soil of Sabinum. But Gaius Aquilius Florus, the precedent, became a seed carried on the winds of history. It took root in the cobblestones of Bologna, in the parchment of the Chancery, in the case law of supreme courts. It flowered as the principle that good faith is the silent partner in every contract, that equity is the unwritten clause in every statute, that the spirit of the law must forever guard against the letter being turned into a weapon. His name is not spoken. But in a courtroom, when a lawyer rises to say, "Your Honor," to allow this would be a fraud upon the court, they are invoking him. When a judge leans forward and asks, "But is that fair?" they are channeling the ghost of the praetors who faced him. He is the eternal what if, the shadow that makes the light of justice seem brighter. He is, in the end, the criminal who became a cornerstone, buried deep, unseen, but essential to the balance of the entire edifice. The laws exist because he was too smart. And we are all, for better and for worse, living in the world those law maritime.